Mrs. Aleksandra Deanoska Trendafilova will present us the country report of Macedonia. Before the presentation, Mrs. Büşra Özçelik wrote a message to chat screen. Please mind this message. It's about the changing times of tomorrow's presentation. Mrs. Aleksandra, are you here? Are you ready?
Yes.
Okay, I saw.
Hello.
Hello.
Greetings from Skopje. Thank you very much. I hope you see me and hear me well.
Okay,
the connection is good.
We can see you and we can hear you very well. And salutes to Skopje, to all Macedonia. The floor is yours, please.
Thank you very much. Again, greetings from hot Skopje. Unfortunately, as Turkey and many other countries, we have problems with this hot wave, but hopefully it is not a problem that cannot be solved. Hopefully the rain and the temperature will get lower soon, and we must go on, we must work. And I'm very honored, I have to say, that I'm part of this international summer school, because this topic is very important. It sends important message because it's coming from Turkey, from your university. And in the last decade in Macedonia also, the efforts and all the analysis and everything that we do, especially on the floor of non-governmental organization, is directed mostly to this issue, the Istanbul Convention and elimination of gender-based violence. I have a presentation and now I will try to share it. First of all, I would like to say that I'm a criminal law professor and I'm also a member of the Ministry of Justice working group that is preparing a new criminal code. We're working now second year on this issue, which is a proof that we do not want to make things quick, because we have a bad experience if you rush into things and if you do not, for example, make certain trials, if you don't prepare the infrastructure of the institutions to implement new things. So we decided to go slowly. But in respect of the Istanbul Convention, we are going a little faster because, as I said, the new criminal code we work on, the process takes 2 years, but it is expected that we finish it at the end of this year. But no matter of that, we are going to adopt amendments of the existing criminal code in order to implement Istanbul Convention in our legislation. Although, as I said, we will have probably a new one within a year or less, within several months, 6 months maybe. So I will now tell you something more about that process, how far we have gone, and what we have done so far. And of course, if you're interested, I will tell you about what dilemmas we had and fight of arguments in the working group on how to implement certain provisions, because Istanbul Convention, we have to admit, all has proved kind of controversial in many countries in certain aspects, and we have to admit that and address the problems properly. So as we do always as Macedonia, we sign the conventions usually immediately, the very same day or within a short period of time after they're open for signature. That was the case with the Istanbul Convention, but we are usually very late with ratification. So as you can see, it was ratified 7 years later. That was not, of course, a problem. It was not a reason that we do not make analysis, gap analysis, conduct researches in the meanwhile. And as we usually do when we academic professors are part of these working groups within ministries, that we even propose changes to legislations even before, let's say, the convention is ratified. So we are going a little step forward. As I said, we ratified it in 2018, and it entered into force in our country about 3 years ago. What reservations do we have? The first one is in Article 30, paragraph 2. It's about the state compensation of the victims. At the moment of ratification, the state compensation of the victims was only envisaged for children who were recognized with a court decision as victims of any kind of violence. But this changed in the meanwhile, namely at the end of January 2021, meaning this year, we adopted a new law on prevention and protection from violence against women and domestic violence, which literally stipulates and guarantees all the rights that arise from international documents and the Istanbul Convention, especially for the victims. So we cannot say that so far we've done a lot. We've done maybe what was optimal according to the legislation and the capacity of the institutions, but the best, we hope, is yet to come, because this issue is very sensitive in Macedonia as well. Still, there are parts of the country, especially smaller towns, rural parts, where the patriarchy and traditional mentality prevails. So in this new law that I mentioned on prevention and protection of violence against women and domestic violence, the compensation of all the victims envisaged as a right. So this is overcome. The next reservation was put on Article 44, paragraph 3. It's about the so-called principle of dual incrimination. That's how we call it in the criminal law theory, meaning that, for example, we will have jurisdiction over a certain case if it is perpetrated in another country abroad, but only if that action is criminalized in both countries. We decided, as this principle is very strongly recognized in our criminal code for almost all cases of crimes perpetrated abroad, we decided to keep this first because we expect that the dual incrimination takes place everywhere, meaning that we expect the countries to incriminate things. Second, the legal certainty is in question. And third, it doesn't think that we will not come back and review these issues again in case it becomes a problem and perpetrators of this crime, let's say, escape from those countries and hide in our country. The principle of dual incrimination in our country is excluded now only for the most severe crimes perpetrated against Republic of Macedonia, meaning acts, crimes against the state, espionage, etc. Then falsification of domestic money, the Macedonian dinar, if it is done abroad, then we do not care whether it is criminalized in another country or not. And it is expanded with corruption cases, crimes against international law, etc. Then we have reservation regarding Articles 35 and 55 in respect one to another. It means that we reserve the right not to apply Article 55 paragraph 1 in respect of Article 35, which is about the physical violence regarding minor offenses, at least until we align our legislation with the Istanbul Convention. The acts of physical violence, we have to admit, that are very broad, and they can be very simple and lenient without visible consequences, but also very severe, very difficult consequences can apply in real situations. So in our legislation, they're envisaged as criminal offenses, but also as misdemeanors. For example, a simple physical act without being accompanied by a circumstance, let's say domestic violence or consequence of bodily injury, etc., especially if it's on a public place, is considered a misdemeanor against public order and peace. But if it reaches the level of bodily injury, we consider bodily injury every slightest manifestation of need for care or something visible. So even a smallest hematoma or scratch will constitute a bodily injury. Then it is considered a crime. Also, almost all the crimes of domestic violence, except one, that's the more lenient bodily injury, are prosecuted ex officio. For this situation, basic or not severe bodily injury, the proceedings take place only ex parte, or if the victim files a complaint or a suit. The next one is the most complicated. It's about Article 59, which is about migration, refugees, etc. The residence status rules in our country at the moment are gender neutral. They are not specific to this matter, but they, because they are wide and neutral, they can cover these cases. However, in the newly adopted law on prevention and protection of violence, we have introduced a principle that is very specific and explicit. It's the non-return principle. I don't know if I will get you the right impression when you translate the provisions. It's about the state not expelling, not returning women, asylum-seeking women and children, and etc., if they will be under threat or under hazard of violence and other human rights deprivation in the other country. How do we define the terms? I had the opportunity to listen to our colleague from Indonesia a little, because I joined you a little earlier. I can see that almost every country, and we are not exception, we are implementing the definitions that are usually part of these international documents. What do we have now, and what will we have, let's say, in future? At the moment, the current Macedonian Criminal Code has this this definition of domestic violence. I will not read it because you have the opportunity to do so, and I decided, because it's an online presentation and sometimes we have full of connection or bad connection, even if you're not in a position to hear me well, to be able to read what I speak. That's why I decided to have this type of presentation. So we have the traditional one on domestic violence. We had a problem of definitions of domestic violence in many laws, civil laws, social protection laws, criminal laws, and each of them had different definitions. And it was really difficult for the judges and prosecutors to be able to cope with that diversity. which is not good from practical and also legal nomotechnical aspect. The law on family provided with definition on domestic violence. Fortunately, it is deleted with the adoption of the law on prevention and protection from domestic violence that was adopted in 2014, which is maybe the most important law for protection of victims of domestic violence, because it covered these temporary measures for protection, which are the most important, because these are the measures that offer the first immediate protection. If you wait for the criminal process to end and the perpetrator to be sentenced, it can take years and the victim may be left unprotected. This latter law is no longer into force, because, as I said, at the beginning of this year, we adopted a new one, Law on Prevention and Protection of Violence Against Women and Domestic Violence, which is maybe 80%, okay, maybe not 80, but 70% the same as the previous one. But now we implemented everything, all the rest, which is provided in Istanbul and other international acts for fight against domestic violence, for prevention of violence against women and gender-based violence. So now we have a more modern law. It is in force, but the application regarding certain provisions is envisaged to start in 3 months, in 6 months. So it basically starts to be implemented now. Of course, there is continuation. There is a continuation, not discontinuation, in the imposing of the temporary measures of protection by court. I will explain about this little later. Here are the definitions from this law, not from the criminal law. Violence against women, gender-based violence against women, and domestic violence. The domestic violence definition is almost the same, with slight technical adaptations. We have no problem with this. But if you ask me about these two definitions, violence against women, which points to gender-based violence, and the gender-based violence against women, which points to violence against women, we have to admit that although they sound good, if you're a judge or a prosecutor, and believe me, I heard this from many judges and prosecutors we work with in this group for amendments of the legislation, they seem that they overlap, that the distinction here is not clearly made. So in the new criminal code, we decided to make maybe a clearer distinction, and I will present these definitions at the end of my presentation. However, you see that at least on paper, in the law, we have the correct definitions. Back to Macedonian criminal code, we don't have one provision, one crime, with title domestic violence. That is not, I think, very useful. What we have is domestic violence, and I put this in brackets, violence against women, because in the positive legislation in the criminal code, this expression is not introduced, but will be soon because the amendments are in parliamentary procedure. So these types of crime, the domestic violence crimes, are in fact special types of other crimes. So we have incrimination on murder, and as a special form of aggravated murder, we have a domestic violence murder. We have bodily injury and severe bodily injury as separate crimes. If they are done within domestic violence circumstances, they are aggravated forms of these crimes, etc. So we have the domestic violence circumstance as aggravating in many parts of the criminal code, and of course, They increased the punishment of the crime. It is prescribed by law, so the legislator took this into consideration. As I said, in most cases, the prosecution is ex officio. In only one, maybe two, is ex parte. Someone will say, why is that so? Because really, in practice, we have cases when the victims file complaints, private suits for criminal prosecution, but then they withdraw them, maybe under influence of the perpetrator, who's usually the husband of the victim or a partner or something similar, member of the joint household or family. But the prosecutors say that if this ex parte moment is not there, usually for this minor, let's say, the more lenient bodily injuries, there is no way that they find out about. So they need this input from the victim from practical part. As I said, amendments of the MCC in order to implement Istanbul Convention are to be adopted soon. And I told you about the new criminal code that will follow. What measures are available to the victims? We have civil law measures, the law I already mentioned on prevention and protection, that covers several protective measures that usually have duration from 3 months to 1 year. Then we have criminal procedure measures. They're usually special procedural protection measure that prevent the victim from re-victimization, etc. Then it's important to note that the NGOs, the social affairs services, and the police are in fact the most important subject in this first line response, you know, because when it comes to criminal investigation and prosecution, it comes a little later. This new law also provides with the possibility of the victims to have due diligence suit right, to file this due diligence suit against the state bodies, institutions, or individuals that work within these institutions if they did not protect their rights by doing what is their job. And then the onus probandi in this case is an obligation of the sued party, not of the suing party. Of course, the suing party will collect evidence and facts in order to this suit to have merit. The free legal aid is provided by many countries, state programs, bar association, NGOs, university clinics, even at the University San Cyril and Methodius, the oldest state university in Macedonia, where I come from, has several clinics where students mentored by their professors and of course with practicing lawyers, attorneys at law, provide free legal aid for many vulnerable categories, including the victims of domestic crimes. Regarding the urgent and temporary protection measures, there is one urgent measure for which the court decides within 24 hours. It is usually a situation where there is immediate and serious danger to the life and physical and psychological integrity of the victim or the members of the family. So there is need for urgent protection. With this measure, there is only one measure called urgent measure, is removal of the perpetrator from the home and prohibition to approach the home. It comes upon a proposal of the Ministry of Interior, so The police officers are entitled to give this proposal, and then the competent court, after receiving the risk assessment that the police has conducted, will, as I said, bring the decision within 24 hours, and the duration of this removal of the perpetrator is from 10 to 30 days. And the other temporary protection measures, which are kind of urgent, but not named urgent, because there is a distinction between this first one and the others, are called temporary protection measures. The court decides within 7 days, usually, if possible, even earlier. And these are, as you can see on the slide, prohibition on threatening to the victim to commit violence further, prohibition to harass, make telephone calls, or any other contacts with the victim, no matter if it is directly or indirectly, prohibition to approach at a distance of less than 100 meters to the residence, school, workplace, etc. As I mentioned, the removal from home regardless of ownership. So the house or the apartment may be his property, but he or she will be removed from the home if being a perpetrator for a period of 10 to 13 days. So this can be urgent measure, but it can also be imposed as temporary protection measure. Prohibition to possess firearms or other weapons. I have to share a detail with you at this point. In this last, I don't know, 5 years, let's say, the NGOs and the journalists are monitoring very cautionly, let's say, the cases of violence against women, and they detected many cases of homicides where people, usually officers, who have firearms because their job is of that nature, are perpetrators of femicides, etc. So it was necessary to have this measure from two aspects. It may be imposed from the civil court, but also, let's say, the Ministry of Defense or the Ministry of Interior can undertake measures so that he is suspended, that his weapon is confiscated, etc. Then to return the items needed to meet the daily needs of the victim and the family. Perpetrators usually do that, deprive them of important things that are needed for the everyday life of the victim or the children. Compulsory financial support of the family, obligatory attendance of a counseling center for perpetrators, mandatory treatment if the perpetrator uses alcohol, narcotic drugs, other psychotropic substances, or has a mental condition, obligatory reimbursement of the medical and other expenses incurred by the violence, in case there are such, because with the new law, all the medical expenses are covered by the state of these victims. But of course, then the state has mechanisms to ask for compensation even from the perpetrator. Then any other measure that the court deems necessary to ensure safety and well-being of the victim. The risk assessment that I mentioned is a very complex issue. It is the police, the Ministry of Interior, and the Centers for Social Affairs, which are within Ministry of Labor and Social Policy, are those that have the main role. Even until now, there were some manuals, but also some formal bylaws, let's say, that describe the process of risk assessment. But in this new law, from 2021, January, we have a strict provision giving explicit solutions how this should be done. So the same institutions are responsible. They need to make it within 12 hours. It's part of the report, let's say, that the police prepares, and the bylaws for all the details are supposed to be adopted by the ministers, Minister of Interior and Minister of Labor and Social Policy. Usually when making the risk assessment, it is the victim that is part of the process as well. But everything that is assessed is mostly directed against related to perpetrator. What person is he like, what he does, is the violence by him or her in rare cases, let's say, repeated, etc. The statistic is our weakest point. The State Statistical Office in Macedonia prepares the reports regarding criminal statistic according to the articles of the Criminal Code. And as I said, the domestic violence crimes are usually just one form of the crime and are just one paragraph of the respective article. So maybe we have a number, let's say we had 130 murders, but we don't know specifically how many of them are domestic violence murders, or 300 bodily injuries, but we don't know how many of them were domestic violence bodily injuries. There are separate, let's say, attempts and records and numbers, data that certain institutions collect. For example, Ministry of Interior. It is easier to find older data, but when I opened yesterday to see if something new I can find on the site, the report named domestic violence data, when I opened, saw that it contains data on traffic accidents. So we are really, really weak at this point. There are researches, regional analysis. You can find data, for example, or on, I don't know, some town or region, but it's not complete. We do not have the real picture what happens on state level. The Minister of Labor and Social Affairs, however, receives data from many, let's say, sources, but still comprehensive and complete reports are missing. That's why this new law on prevention and protection of violence against women and domestic violence stipulates new obligations for all the subject in the process that should collect data. Even courts and public prosecution offices and the State Statistics Office has the obligation to prepare national research on domestic violence. Hopefully next year or in a year or two, we will have the exact data. According to some researches, and I see that I passed the time, maybe I will leave something to the questions and answers part. I will just say that some monitorings showed that 83% of the domestic violence victims in criminal proceedings are women, 17% are men. On the side of the perpetrators, 89% of the perpetrators are men. It's not always men against women. We have economic violence, psychological, domestic violence, sometimes is man, son against, let's say, the sister, the mother, the father, the brother, etc. Several months ago, the Minister of Labor and Social Affairs reported that during the pandemics, especially during the lockdowns, which we had last summer, curfews that lasted for several days in a row, the domestic violence increased for about 10%. Because the free movement out of home was suspended. But the police was paid attention that they should especially be careful and take into consideration every report, every call from a woman, and then to let her go out of home in order to be protected in shelter center or any other possibilities. The cooperation is good when it comes from the judiciary or the public prosecution, giving the police as in the role of judicial police to investigate, to gather evidence, etc. But the other direction is not really good. Because so far the main detective flaw was the ignorant attitude of the police, something which is in a great extent overcome in the last several years. But before that, we really had a problem. We had rare cases, including, let's say, not reporting the case to public prosecutor by the police, who had the victim in their offices, who came to complain, or let's say letting the victim stay in the police offices for a couple of hours, trying to calm her, and then send her home to make up things with her husband or partner. Unfortunately, several of these cases resulted with something else. Women which were victims of physical violence by their husbands for years ended up committing murders against them. So this must be prevented. The victims trust the judicial system? Not really. No one trusts really the judicial system in Macedonia. A research of the NDI of 2020 showed that, I will show you the black and white, the pure black and white, only 3% of the interviewed said that they have full confidence in the judiciary and public prosecutions. This is the black part. Another black part, no, this is the white, but it's the small one. The black part is that almost 50 have no trust at all. In between, we have people who have little trust or don't trust to a big extent, etc. But however, these numbers are really bad. Also, the monitoring of trials in period from 2014 to 2017, proved that 35% of the perpetrators were sentenced in criminal procedures with effective sentence, imprisonment, but 65 got suspended conditional sentence. Perpetrators in our country, when they get conditional sentence, mean they walk free, they usually think that they don't have a responsibility. We have shelter centers for mothers and children. If children were victims of any type of violence, they also have special rights. The law envisages measures for protection against re-victimization. I will not read them. I will let you read them. It's usually something about the procedure, let's say, taking a statement at the place of reporting and not letting the victim go around institution in that distressed condition, taking the statement of the victim in a police station or public prosecutor's office with audio visual recording, and that to be used as evidence in all the stages of the criminal procedure, not to invite her to give statements all over again and, as I said, to be re-victimized, etc. So more or less about the shelter centers. We have international interventional accommodation in very difficult and dangerous cases where the victim is immediately admitted for at least 24 to 72 hours, and then placement in shelter centers with her consent, of course, which can last up to 3 months with possibility of additional 3 or 6 months. The shelter centers are on secret locations, and even visits are not allowed there. If victims want to have visits, it will be done outside of that the building. So there are 11 shelter centers and several counseling centers. that's all for now, but please let me know if you are interested and if we have enough time so that I present you what we will introduce in the criminal code regarding stalking, female genital mutilations, and sexual assault and rape, where we had most, let's say, difficult fight. Not that we didn't want to incriminate these actions. We had fights, intellectual fights with arguments, not physical ones, about the terminology we will use. So, as I say, the time is not enough to present everything, but if you're interested in anything regarding this presentation and the future amendments implementing Istanbul Convention, please let me know. So what we will introduce. The definitions more or less are the same, but if you see now the definition of violence against women and gender-based violence against women, you will see that the first is wider, broader, and is somehow distinctive from the other. But if you ask me, judges and prosecutors, when they will make their arguments in the acts and in the verdicts, will usually not distinguish one from the other. They will usually use, as that is my opinion, both these expressions, that they detected violence against women and gender-based violence, they will use them together. The female genital mutilation, as you can see, is a simple incrimination. Almost everything is taken as a wording from the Istanbul Convention. Of course, we did not use the Latin expressions like labia minora, labia majora, clitoris, etc., because it is not how you mnemotechnically do that in the criminal code. Plus, it is not the judge or the prosecutor that will investigate this directly. It will be always the medical expert that will determine if any mutilation of women's external genitalia took place. I have to say that by some persons coming from NGOs, there was a pressure that we put this Latin expressions, but it was not acceptable. As you can see, 6 months to 5 years of imprisonment is the basic, the sentence for the basic part. If there is coercion, it is an aggravated form. Then we have also the same punishment, little less is punished, let's say, the perpetrator if he encourages or helps a woman, so there is no coercion, etc. It's 6 months to 3 years. But if we have aggravating circumstances, I'm sorry, like hatred against a girl, or the consequences more severe, serious bodily injury, etc., then the punishment is 1 to 8 years. The stalking is something new because maybe it is usually present, and there is a lot of practice and precedence in USA, let's say. For our countries, it is something new. So we have this wording: person who repeatedly, without authorization, follows, persecutes, or otherwise interferes in the personal life of another. We put this without authorization because, you know, following a person with authorization, let's say as a part of special investigative measure, is something legitimate, and this is not the case. Or establishes or seeks to establish unwanted contact with him, her, by moving in the space where that person is located, or abusing personal data, or using media or means of communication, or otherwise psychologically abusing, harassing, or intimidating him, her, and thereby causing a feel of insecurity, anxiety, or fear. So this is how we will incriminate stalking, and the imprisonment of up to 3 years or fine. This means fine or imprisonment from 30 days to 3 years, because the minimum in our country is 30 days. Maybe you know, if you have time, search a little. We had the public room scandal in Macedonia, the group on the application Telegram, where the perpetrators were exchanging photos of young girls stolen on social media, and then making unwanted contacts with these girls. It was something that was really seriously taken in our country, and I think the stalking incrimination will help to prevent such situations. Sexual harassment is something that we have had it legally addressed, usually in the legislation labor, when it is performed at the workplace, and other laws, because we had a special law on prevention of mobbing. Usually it was subject to civil and misdemeanor liability with narrower extent, and now we decided to cover it in a wider extent. You can see it on the slide. I will not read it. I can send you these things if you need for your further researches. And now we have the sexual assault and rape. Here we had that dilemmas about the terminology. As you may already know, the crime of rape in the Macedonian criminal law theory is a complex crime consisting of 2 elements. The first is some sort of coercion, which means physical force application or threat, plus the sexual intercourse. That's the classic view, and that was the case until now. With ratification of the Istanbul implementations, it was expected by us also to cover those cases where force is not an element of the crime, meaning to criminalize all non-consensual acts. So the first idea of this group of professors, judges, prosecutors, and representatives from NGOs and relevant ministries is to create 2 separate crimes in 2 separate provisions. This was good from nomotechnical aspect, because you can see this, 2 pages of text. We have the same with money laundering, 13 paragraphs. It is so difficult to implement. The judges and prosecutors are driven crazy by these acts. So we wanted to incriminate the non-consensual sexual actions as sexual assault, and the classical sexual violence form, which includes force, to be that classical rape. Because I don't know if you know, in Macedonia, the word rape, silovanja, contains the word force, sila, which means physical force. So if in Macedonian you use the same word, and this was like the idea of the NGOs to put everything under rape, this most severe cases of rape where the victim was really forced by physical force with injuries and everything, and these cases where it was not clear, in many cases in practice it may be the case, we can not neglect the fact that maybe false accusations will take part from men and women both. Believe me, time will show that we put equalization between the 2 parts. And it would be, as I said, nomotechnically better if we have sexual assault in one provision and rape in another. But at the end, the NGO position in the cabinet of the Minister of Justice one. So now we have everything put in one article, Article 186, sexual assault and rape. This is how we put it regarding wording. A person who, without clearly expressed consent of another, assessed in the context of the circumstances of the case, performs sexual intercourse or other sexual action, etc. It is important, judges and prosecutors say especially, that the perpetrator receives in any way the information that the victim doesn't want the sexual intercourse. Some people were trying to say that explicit consent, explicit no is not necessary. That is okay. Maybe you cannot say no in certain circumstances, but the victim should somehow show with, let's say, pushing back or I don't know, manifestation of movement that will make the perpetrator be clear about the will of the person. But what was the initial idea of some of the NGOs to have literally nothing might lead to situations when someone will accuse another one of rape without even needing to say or show no. I've heard, unfortunately, and I think that is killing our cause and our fight for gender equality, especially when women say it's payback time. It's not payback time. We should make things be on the right position, but no retaliation. So everything we do, it should be in a manner that will not, at the end of the day, minimize the meaning of the rape. The classical rape, using force or threat against another to perform the intercourse, you can see is in paragraph 3 to 10 years of imprisonment, and the non-consensual, where there is no force and no shown objection, 1 to 8 years. Then we have the threat there, he or she, or a person close to him, her, will discover something that will harm the honor and reputation. It's a sort of extortion, sexual violence, and other aggravated forms you can see in this respect. That is the basic dilemma about this crime. And at the end, I will finish with this. In these amendments, we give specific explicit incrimination of the femicide. Namely, we will add a paragraph in Article 123, which will cover deprivation of life. That's how we use the expression for murder in committing domestic violence, or, this is the new part, gender-based violence against women. And the sentence for this prescribed by law is minimum 10 years or life imprisonment. Translated into our criminal law language means 10 to 20 years or life imprisonment, or the judge may, instead of life imprisonment in certain cases, impose imprisonment of fixed 40 years. So more or less, there's no time for more, but more or less these are the main amendments that we'll make in the criminal code in order to implement the provisions of the Istanbul Convention. Thank you.
Thank you to Mrs. Professor Trendafilova for your great presentation, which expresses and briefs the situation in Macedonia. If there are questions from the participants. We can read from the chat board. Any questions from anyone? As one question from Mehmet Utku Savari, I will read it for you and for recording issued. Thank you very much for your great presentation. As you say, legal studies for implementation of the Istanbul Convention continues for Macedonian legislation with new amendments or new codes such as new criminal code. I wonder the general reaction of the people in this society for these studies. What are your observations about this?
If I understood well, the question is, what is the reaction of the people about this,
Yes.
right? About the implementation and the changes. Well, let's say when we presented this soon to be adopted amendments in the media, there was a really positive reaction regarding incrimination of the stalking, because sometimes we may say it's a bad joke. Stalking is kind of way of living for young people. It's somehow very common. For example, if you go to Sweden or I don't know, other countries that have different mentality, it is something that is to be condemned. But in our culture, you know, sending messages over and over to a girl, and etc., it was kind of normal. But that changed, as I said, with this public room case, and girls are especially happy that now they might be legally protected. Also, I must say that public prosecutors are somehow concerned regarding the evidence. If the unwanted contact is somehow covered, you know, in messages, you can obtain material evidence, it will be easier. Also with the so-called sexual assault, what if you have cases, her word against his word? There we have little dilemmas, how it will be in practice. You know, it's a great idea, you know, the saying, the road to hell is paved with great intentions. But I must say that for certain of these proposed incriminations, practitioners, judges, and prosecutors think that will be faced with difficulties in evidence. Even in one of the meetings, you know, one of the prosecutors said, you know, we will be overloaded with private complaints for prosecution from boys and girls, women and men who were, let's say, dumped by their partners, and they will claim they were raped, etc. They might be abuses, and really in the cases where you cannot prove other than verbal testimonials, other evidence, we will have to wait several years at least to see how this implements. As we say, the judiciary has the power to make its unique approach. Of course, it has to be argumented and to see how they will swim in these difficult waters. Thank you.
Thank you. Thank you too for your answer, Mrs. Professor. There is or there are any more questions?
Thank you, dear colleague, for the question.
Is there any more question? I suppose there is no more question. And again, I thank you, Mrs. Professor Trendafilova, for your great presentation. And thank you too for the presentation in the previous section by Professor Natalina Naibaho. And thank you to everyone for participating these sessions and all the contributions to everyone. I benefited from all these two presentations, and I hope this is for every participant. So it's the end of today's program, and if you wanna say something more, we can get from you or the other participants. If everything is okay, we will finish the session on the Zoom.
Thank you all. Greetings and stay safe.
Okay. See you soon, everybody.